Hi, this is Marisa Portuondo, and this is the 5th video in our litigation series. Yesterday we discussed what a motion is, and the reason I did that is so that you would better understand this video, which is the motion to dismiss. Now, we have talked about a summons getting, a complaint being written and filed with the court, the summons being issued by the court, the process server going out and serving the defendant with the summons and the complaint, and the defendant filing an answer. Now, the other alternative to filing an answer that's extremely common is what's called the motion to dismiss. And just like an answer, it is considered a response to the complaint. So you do only have 20 days to get that motion in and filed. Now, what is a motion to dismiss? A lot of clients get confused with a motion to dismiss because of the name. And the reason is that obviously they're like, ooh, the case is going to be dismissed against me. Or if they're the plaintiff, they're like, oh no, my case is going to be dismissed. You know, I just spent all this money and stress and effort, and now my case is going to get thrown out. Well, it's very rare that that actually happens. And the reason is that the motion to dismiss is a very technical motion. And basically what it says is, hey, this complaint, this lawsuit, which contains causes of action, okay, the causes of action are just not being pled properly. Now, a cause of action is basically like a formal allegation that is being alleged against the defendant. So, for example, a breach of contract. That is a very common cause of action, especially in business and construction law. Negligence can be another type of civil cause of action. There's just, so many different types, but each type of cause of action has elements to it. And these are things that must be alleged in order for you to properly state a cause of action in your lawsuit, also known as your complaint. So when an attorney files a motion to dismiss, what they're saying is, hey, judge, this attorney on the other side, they didn't write all the proper elements out, or, they failed to do XYZ, and therefore their complaint is not 100% valid. Some defense attorneys, unfortunately, also tend to use the motion to dismiss as a delay tactic because it does toll the time where they need to file an answer. Now, when a motion to dismiss gets filed, like everything else that gets electronically filed, it gets served automatically on the other side, and that will usually trigger action on the part of the attorney representing the plaintiff, because now the plaintiff's lawsuit is getting slowed down. So usually it will either be worked out where the plaintiff might say, okay, you know what, you're right, I did mess up there, let me fix that, and let's move along, and then, you have to file your answer, or the attorney who wrote the complaint will disagree. And he'll say, hey, or he or she will say, we got to go to court. And then once again, they will go up in front of the judge, as I explained in the last video. They will argue, and the judge will render a decision in the form of an order. I hope that's not getting too technical. So if the judge grants the motion to dismiss, what that means is the judge is saying, hey, you know what? I agree with you. This complaint does have issues, and almost always the attorney representing the plaintiff will have an opportunity to correct whatever is wrong with the complaint and file what's known as an amended complaint, and then it starts all over again. The other side will have time to either file an answer or, again, another motion to dismiss if they feel that there's still an issue. So as you may have noticed by now, there is a theme here, which is, these things take time. Unfortunately, there is a lot of time and a lot of waiting involved in litigation. We do try as much as possible as attorneys to work things out as much as we can without going to court. Sometimes it's inevitable, and the motion to dismiss is just another step in that process. So the next thing we're going to talk about in following videos is discovery, and that's where litigation can get a little bit crazy. So I will break that down for you guys in the next few videos. Thanks.